Assalamu alaikum. We are now having lecture number 19 of Pakistan Studies. The topic that we will discuss in this lecture is the 1956 Constitution of Pakistan. In lecture number 18, we have discussed the stages through which the Constituent Assembly of Pakistan went through to frame the Constitution. Two Constituent Assembly dealt with the matter and framed the Constitution, which was introduced in Pakistan on 23rd March 1956. 23rd March, as you know, is an important date in the history of Pakistan. You would recall that on 23rd March 1940, the Lahore Resolution was presented for approval in the annual session of the Muslim League held at Lahore. So when the Constitution of Pakistan was framed, it was decided that it would be formally introduced on such a date of historical importance, and therefore on 23rd March 1956, this Constitution was introduced. The 1956 Constitution of Pakistan had 234 articles, clauses, and 6 schedules, in which the whole constitutional framework and set of principles for governance and power management have been outlined. This Constitution, that is the 1956 Constitution, describes Pakistan as the Islamic Republic of Pakistan. That is the official title of the Pakistani state, the Islamic Republic of Pakistan. If we look at the provisions of the Constitution, we find that there is an impact of Government of India Act 1935 and the first interim Constitution of 1947 on this Constitution. Some of the articles included in the Government of India Act 1935 and the first interim Constitution of Pakistan have been incorporated in the 1956 Constitution with some modification, few adjustments here and there, and in certain cases language is very similar, if not the same. So in a way, there is some continuity from the previous constitutional document to this document, although it is different from the previous one in most respects, but there is some continuity. And now I will be discussing the basic features of the 1956 Constitution so that you have an idea of what kind of constitutional system came into being with the introduction of that Constitution, what kind of state institutions were created, what was the relationship of different states, institutions with each other, with public at large, and how the power was distributed and how the power was to be exercised. The first significant feature of the 1956 Constitution is that it provides for a parliamentary system of government. Under the parliamentary system of government, the executive authority is vested in the President, but he exercises that authority on the advice of the Prime Minister, except in the matters which are left to the discretion of the President. To simplify this statement, under the parliamentary system, you draw a distinction between the functions of the head of the state and head of the government. President is the head of the state, and his powers are limited. He performs certain limited functions in his discretion. But most of his powers are exercised by the head of the government, and that is the Prime Minister. So Prime Minister and his cabinet are the executive heads of the state. He is the head of the state and Prime Minister is the head of the government. And he exercises power as defined by the Constitution, as given in the Constitution, although in theory those powers may be assigned to the President. There are certain functions which head of state performs. Usually these are limited functions, ceremonial functions. The precise nature of the powers of the President under parliamentary system may vary from constitution to constitution. Some constitution may give some more powers to the President, some less. However, the guiding principle is that the powers of the President would be limited and in most cases ceremonial, with the exception of certain discretionary powers or powers in his own judgment which he exercises. For example, certain non-controversial appointments are made by the President, key and important appointments, and certain other powers. But the real authority of government, of running the administration, day-to-day affairs of the state, is the job of the Prime Minister, who runs the government. And that is what was provided in the 1956 Constitution of Pakistan. In this case, the President was to be elected. There was to be an elected President, and he was to be elected by the members of the National Assembly and provincial assemblies for a period of 5 years. And the minimum age for President was 45 years, and under the Constitution, the President's office could only be held by a Muslim. That was a condition provided in the Constitution. The President was part of the legislative process of the state. All laws passed by the Parliament, in this case the National Assembly, were to be presented to the head of the state, that is the President, for his approval. He could sign those laws, and if he signs those laws passed by the Parliament, it becomes law. He could reject and refuse to sign, or he could return the law for reconsideration of the Parliament, in this case the National Assembly. The general practice is that President, if he doesn't agree with something, he returns the law for reconsideration, for a review, rather than rejecting it. But he has the power to reject a law passed by the Parliament, and in this case the Assembly can again pass that law with or without changes. Then the options of the President in parliamentary system is limited to say no. The real power is exercised by the Prime Minister. Prime Minister under the 1956 Constitution was appointed by the President. But there was a condition on that. The Constitution provided that the President would appoint a person as Prime Minister who, in his opinion, commanded the support of the majority in the National Assembly. So, if in the National Assembly a party has got a very clear majority, then the President is bound to ask the leader of that party to form a government. But if no party has the majority, then President can exercise some discretion in inviting the leader of a party or of a coalition to form a government. But the overriding principle is that the person who is appointed Prime Minister must command the majority support in the National Assembly. A follow-up of this principle is that if Prime Minister loses majority in the Parliament or is unable to demonstrate his majority in the Parliament, that Prime Minister cannot hold on to his office. Under the 1956 Constitution, the President could remove the Prime Minister, but this power was to be exercised only if the President was sure that the Prime Minister doesn't have a majority in the National Assembly. In this respect, that is, whether the Prime Minister has the majority support or he has lost this support, the President was to be the sole judge. If President is convinced for one reason or the other that the Prime Minister has lost the confidence of the National Assembly, then he could ask the Prime Minister to resign. But there is a convention, constitutional convention, that he could also ask the Prime Minister to demonstrate his support on the floor of the House. But under 1956 Constitution, President was not obliged to ask him to show his strength. he could, if he is convinced, could remove the Prime Minister. Prime Minister was the person who would run the government under the 1956 Constitution with the help of a cabinet of ministers. And whole cabinet, ministers and others, sometimes there are Minister of State or Deputy Ministers. So the cabinet as a whole, including Prime Minister, were responsible to the National Assembly. Responsible to the National Assembly means that they were answerable to the National Assembly. The members could question them, ask them about their policies, and in the ultimate analysis, the Prime Minister and the Cabinet must enjoy the support of the majority of its members. And if that is not the case, the National Assembly could remove a Prime Minister and his cabinet through what is known as vote of no confidence. That means if majority of the members of the National Assembly under 56 Constitution voted against the Prime Minister, then Prime Minister could not continue. Either he would resign or the President would remove him and ask the person who now commands the majority to form the government. And if no government can be established, then President could also go for general elections. So this was the situation under the 1956 Constitution, that is the parliamentary system of government. In fact, this was the system that was functioning before the 1956 Constitution was introduced, that is under the 1947 interim Constitution. The second important feature of the Constitution was that it created one house parliament, which was named as the National Assembly. It had one chamber, one house. Traditionally, in federal system of governments, there are two houses. One for representation of the constituent units of a federation, and second for the representation of the people. However, under the 1956 Constitution, one chamber National Assembly was provided. The reason was that with the integration of the province of West Pakistan in October 1955, that we have discussed in our previous lecture, there were two provinces of Pakistan, East Pakistan and West Pakistan. So since there were two provinces, they decided to form one house. The other principle agreed to was parity or equality between the two provinces or which are sometimes described as two wings of Pakistan. Parity means that both East Pakistan and West Pakistan would have equal representation in the National Assembly. So because of integration of West Pakistan as one province and because of acceptance of principle of parity between the two provinces, only one house was provided. National Assembly consisted of 310 members. Out of 310, 300 were general seats and 10 seats were reserved for women. So in this way, 300 plus 10, it total comes to 310. And the general seats were to be elected directly on the basis of principle of universal adult franchise. And at that time, it meant that people with the age of 21 and above had the right to vote. And ultimately, in 1957, the National Assembly opted for principle of joint electorate. Previously, a separate electorate as inherited from British India existed, but in 1957, principle of joint electorate was adopted. This single house National Assembly had all legislative powers for law making in respect of the subjects that were either assigned to the federal government or were in the concurrent list that we will discuss slightly later. And after law has been passed by the National Assembly, it would go to the President for his signatures, and as I have described a couple of minutes ago, President could either sign it, return it, or reject it. But the Assembly had all the legislative powers. So far as financial powers are concerned, the budget, that is income and expenditure of the federal government, had to be passed by the National Assembly. And National Assembly had the power to accept it, to reject it, or to reject particular request for funds in the budget. It had the power to do that, with the exception of consolidated fund list. There are certain items of expenditure for the state of Pakistan that cannot be changed through a simple majority. That is consolidated fund list, and I give you a couple of examples. For example, salary of the President under 56 Constitution was part of the consolidated fund list. Salaries of the judges of the Supreme Court and High Court, that is Superior Judiciary, salary of the members of the Federal Public Service Commission, and then there are certain other important offices for which funding is provided, and if they want to change these things, there had to be a special procedure. So with the exception of this consolidated fund list, rest of the budget could be rejected straight away if the Assembly wanted. The general tradition in the parliamentary system is that if budget is rejected by the Parliament, it is considered to be a vote of confidence in the cabinet, and consequently government collapses. So the Assembly had the financial power to assert its authority. The overriding position of the National Assembly was that it had control of the executive, that is the Prime Minister and the Cabinet. And I have described that, how the National Assembly could remove Prime Minister from the office, and it had the power to ask questions, move resolutions, adjournment motions, take members part in and criticize the government or make proposals and suggestions to the government. So the government was responsible to the assembly, that is the National Assembly, set up by the Constitution of 1956. The third feature of the 56th Constitution was the federal structure. The 1956 Constitution established federation in Pakistan, and this federation at that time comprised two provinces, provinces of West Pakistan, provinces of East Pakistan, plus other areas which were under the direct control of the federal government. The powers were distributed between the center and the provinces. 3 lists of subjects or 3 lists of powers were given in the Constitution. 1, the federal list, which included items that were the exclusive concern of the federal government, which means the National Assembly could legislate for all the subjects mentioned in the federal list. The second list was the provincial list, and provincial assemblies could make laws for provincial list. The third list was the concurrent list. This third list included items for which the National Assembly and provincial assemblies could legislate. However, if the National Assembly had made a law, that the law of National Assembly will have a priority over the law made by the provincial assembly. This principle of division of subjects into 3 categories was adopted from the first interim constitution and the Government of India Act 1935. The only difference was that in case of the 1956 Constitution, the subjects allocated to the federal government were reduced. Some of those were transferred to the list, but more or less the principle of 3 categories of powers was followed in 1956 Constitution. This Constitution provided for a provincial structure. Each province had a provincial legislature elected directly by the people, and even in provinces, parliamentary system was introduced. That is, Chief Minister would be the head of the government, Chief Minister responsible to the provincial assembly, the way Prime Minister is responsible to the National Assembly. The governor was appointed by the President in consultation with the Prime Minister. The governor's functions were ceremonial. The provincial executive power was exercised by the Chief Minister, not by the Governor. In this federal system that Pakistan adopted, Centre was strong, although provincial autonomy was given to the provinces, but Centre was strong. Traditionally, Centre in Pakistan has been strong, going back to the British period. So a tradition of strong Centre existed because there were certain powers with the central government or the federal government that enabled it to step into the provincial domain. For example, emergency powers. If there was a threat to political or economic stability due to internal or external reasons, let's say war from outside, or for certain development within Pakistan that threatened stability, economic and political stability, the federal government could exercise emergency powers. Which means if federal government exercises emergency powers, the domain and autonomy of the provinces would be restricted. There was another power that allowed Centre to step into the provincial domain or provincial field. If for some reason there is a constitutional breakdown in a province, that is, the provincial government cannot function, or central government has come to the conclusion that provincial government, the chief minister and his government cannot function in accordance with the constitution, then president could ask the governor to take over the administration. So sometime this would be called presidential rule. And federal government in Pakistan from 57 to 56 and then from 56 to 58 under the 56 constitution did exercise this power to change governments. We say principle of federalism was there, provincial autonomy was there, but Centre was strong under the 1956 Constitution. Fourth feature of the Constitution is the establishment of an independent judiciary. When you have a written constitution, as was the case with the 1956 Constitution, and when you have a federal system of government, you need an independent judiciary. And in this case, the judicial system started with the Supreme Court on the top, then each province had a High Court of East Pakistan, High Court of West Pakistan. Then we have lower court system, that is district level and below district level. But the term superior judiciary is used only for the Supreme Court of Pakistan and the provincial high courts. The Constitution for the service of the superior judiciary judges of the Supreme Court and the High Court, security of tenure, so that they are independent. And the judiciary, especially the superior judiciary, the Supreme Court and the High Courts, had to play an important role so far as interpretation of the Constitution was concerned. If there was some dispute, if there is a conflict or dispute of interpretation between various governments, provincial government, central government, different provincial governments, then the matter could be taken to High Courts or the Supreme Court. Superior judiciary also had powers with reference to rights, fundamental rights given in the Constitution, or if some citizens have complaints against government, The superior judiciary had the power to issue writs. Writs means that it could order the government to do certain things, or it could order the government not to do certain things. It could order the government through habeas corpus to produce a person before the court, so that court can adjudicate the matter. So there was an independent judiciary in the 1956 Constitution. Another feature, that is the fifth important feature of the Constitution, pertained to fundamental rights, bunyadi hukuk. Under the democratic system, all citizens, irrespective of caste, creed, or residence in any area, they are provided certain basic civil and political rights. Certain protections and securities are offered by the Constitution to all citizens. The Constitution of Pakistan, 1956, provided for certain political rights, civil rights. For example, some of the rights are known as freedom of press, personal freedom, freedom to express your views, to write your views, security, personal security, freedom of religion, to practice a religion, to live according to the principles of your religion, and to form political organizations. These are all basic rights which are provided in the 56 Constitution. However, fundamental rights are not unconditional, because the rights of one person become the obligation of the other person. Rights and duties go together. My right is your duty, and your right is my duty. I have to respect your rights the way I want you should respect my rights. Therefore, grant of fundamental rights, civil and political rights, doesn't mean that a person is free to do anything he or she wants to do. Within the parameters of law, within the limits of the Constitution, fundamental rights are to be exercised. And under special circumstances, the state can suspend those rights. If there is an emergency for some reason, then the government, through the president, has the power to suspend civil and political rights and to exercise extraordinary power. So, in other words, fundamental rights were provided, but those were to be exercised within the defined limits. And if somebody feels that the policies of government or a particular law or particular action of the government or some action of some group, non-government group or individual violates fundamental or basic civil and political rights, that person could go to the judiciary, in this case the high courts, the provincial high courts and the Supreme Court, for the rehabilitation and restoration of the rights. So in a way, judiciary also plays the role of protector of civil and political rights. Primarily, it is the responsibility of the government to see to it that civil and political rights of the individuals, that is the citizens of the state, are protected, and all citizens have an opportunity to make use of those fundamental rights. and if that doesn't happen, then one could go to the judiciary. But again, these rights are conditional rights and state has the power to suspend them. Another important feature of the Constitution of Pakistan 1956 was the directive principles of state policy. There are certain principles given in the 56th Constitution as the guidelines, as the directives for state policy making, for the rulers who exercise power, who are holding key positions in government. There are certain directive principles which should serve as guidelines. And the Constitution of 1956 provides several, those directive principles, and one or two I can mention here to show what kind of principles were these. One basic principle was that the state of Pakistan would create conditions to enable the Muslims to live in accordance with the teachings and principles of Islam. There were other directive principles, for example, for providing employment, jobs, looking after the interest of the people. These directive principles were only in advisory nature. That is, one could not go to the Supreme Court or High Court and say that such and such directive principle is not fully implemented, you issue an order. So these could not be challenged in the judiciary, but these were the guidelines and advisory in nature. The seventh important feature of the 1956 Constitution is its Islamic character. I said in the beginning that the official title of the state of Pakistan under the 1956 Constitution was the Islamic Republic of Pakistan. The preamble of the Constitution is based on the Objectives Resolution. The Objectives Resolution had outlined the basic principles of those constitutional framework, and all those principles are incorporated in the preamble. Preamble of a constitution outlines the goals and objectives, the aspirations, the desire about the political system you want to create. Therefore, like the Objectives Resolution, the preamble, which is always in the beginning of the Constitution. In fact, the Constitution, any Constitution, starts with a preamble where you declare your intention as to the type of system you wish to create. So preamble, therefore, is very important to understand the ultimate goals. So the preamble, like the Objectives Resolution, starts that sovereignty all over universe belongs to Allah, Almighty Allah alone. And then you find the text of the Objectives Resolution in the preamble, where the framers have tried to put together the basic notion of Islamic polity as well as the modern state notions like democracy and rights. So the principle of sovereignty belongs to Almighty Allah has been the characteristic feature of the 1956 Constitution, and it continues to be the feature of the subsequent constitutions. So you also have several other provisions in the Constitution which link Pakistani political system and Constitution to the principles and teachings of Islam. The Constitution says that there will be no law in Pakistan that is in conflict with the principles and teachings of Islam. And all laws, that is the existing laws, were to be brought in conformity with the Islamic provisions. For this purpose, a commission was to be appointed that was to look into the existing laws and see if there are conflicts between the existing laws and teachings and principles of Islam. And if they found out some conflict, that law had to be changed. So the emphasis on Islam was very clear. And I have also mentioned, while discussing the directive principles, that one of the directive principles of the Constitution was that state will create enabling conditions to enable the Muslims of this country to organize their lives in accordance with the teachings and principles of Islam. That was one of the responsibility of the state of Pakistan under the 1956 Constitution. Then you could look at number of other things. So far as the issue whether a law is Islamic or not, the National Assembly had the ultimate power to make or not to make a law. There was no supra-National Assembly body to decide that. The Assembly was to make law and make sure that laws do not violate teachings and principles of Islam. Or the other alternative was that one could go to the superior judiciary if one finds some kind of conflict between Islamic laws and the ordinary laws of the state of Pakistan. This emphasis reflected the nature of the Pakistan movement and the desire of the Pakistani leadership as reflected in the objectives resolution to identify the state of Pakistan with Islam. Before I conclude, let me say few words about the working of the Constitution. This Constitution was introduced on 23rd March 1956. It functioned till 7th October 1958. On 7th October 1958, the military took over the powers under the leadership of its Commander-in-Chief, General Ayub Khan, who abrogated the Constitution along with then President Iskandar Mirza, and assumed power under martial law. This brought an end to 1956 Constitution. In other words, the 56 Constitution lasted from 23rd March 1956 to 7th October 1958. This brings an end to our discussion of the features of the 1956 Constitution. Khuda Hafiz, until we meet again.